Welcome to Lawyer Up by NDV Law. This is Attorney Karlo Nicolas, Senior Partner of Nicolas and the Vega Law Offices. In today's video, we will talk about prohibited claims in food labels, which the Food and Drug Administration of the Philippines prohibits and punishes. To protect the public against dishonest or misleading advertising or promotion, and to ensure that every consumer acquires sufficient knowledge to be an informed consumer, particularly in the choice the consumer products that he or she wishes to purchase or consume, the Food and Drug Administration issued a regulation called Administrative Order Number 2014-0030. This FDA regulation provides for the labeling guidelines of pre-packaged food products in order to protect the consumer against hazards to health and safety and to provide information and education to facilitate sound choice in the proper exercise of their rights. The FDA regulation covers all types of food, including any processed substance which is intended for human consumption, drinks for human beings, beverages, chewing gum, and any substance which has been used as an ingredient in the manufacture, preparation, or treatment of food. It also covers pre-packaged food. For example, food that is packaged or made up in advance in a container, ready for sale to the consumer or for catering purposes. It requires manufacturers, importers, and distributors to comply with food labeling requirements and standards. Now, under this regulation, manufacturers and importers and distributors must disclose the required information in product labels. As the most readily available material to inform the consumer about the product contents, shelf life, and traceability, among many others, the FDA strictly regulates the use and contents of product labels. In labeling pre-packaged food products, including food supplements, whether locally manufactured or imported into the Philippines, a food establishment has to be extra careful about the use of words or information pertaining to the food product being produced, sold, or marketed. The FDA regulations strictly prohibit manufacturers, importers, or distributors from describing or presenting pre-packaged food labels in a manner that is false, misleading, or deceptive, or is likely to create an erroneous impression regarding its character in any respect. The FDA defines the following representations or suggestions, whether directly or indirectly, if found in the food label, as a misleading, deceptive, or untruthful declaration. Take note, these are the claims or statements which are not allowed and should not be present in food labels. Number one, that the food, because of the presence or absence of certain dietary properties, is adequate or effective in the prevention, cure, mitigation, or treatment of any disease or symptom of an illness. Number two, that a balanced diet of ordinary food cannot supply adequate amount of nutrients. Number three, that the food has dietary properties which, when such properties are of no significant value or need in human nutrition. Number four, that a synthetic vitamin in a food is superior to a natural vitamin. Number five, claims which could give rise to doubt about the safety of similar food or which could arouse or exploit fear in the consumer. Number six, claims which highlight the absence or addition of any food additive or nutrient supplement, if the addition of such food additive or nutrient supplement is not permitted or prohibited. Number seven, claims on the absence of beef or pork or its derivatives or lard or added alcohol are prohibited if the food does not contain such ingredient. Number eight, claims on the absence of any substance when the food does not contain such ingredient. Number nine, claims that the product is superior to any existing product of the same kind that cannot be substantiated. Number 10, claims stating that any given food will provide an adequate source of all essential nutrients, except in the case of well-defined products for which a codex standard regulates such claims as admissible claims, or where the FDA has accepted through an issuance that the product is adequate or is an adequate source of all essential nutrients. Now, this is based on the Codex General Guidelines on Claims, CAC-GL-1979, which was amended in 2009 on prohibited claims. Number 11, claims as to the suitability of a food for use in the prevention, alleviation, or cure of a disease, disorder, or particular physiological condition unless they are in accordance with the provisions of Codex standards or guidelines for food as developed by the Committee on Nutrition and Food for special dietary uses and follow the principles set forth in these guidelines. Number 2, in the absence of an applicable Codex standard or guideline, it is permitted by the FDA. Number 12, meaningless claims, including incomplete comparatives or superlatives. Number 13, claims as to good hygienic practices such as wholesome, healthful, or sound. Now, what happens if your product contains these claims? Republic Act number 9711 of the Philippines defines misbranding as misinformation or the use of misleading information on the label or other information materials required by the FDA. If any misleading, deceptive, or untruthful declarations in food products are found, these declarations will render the food product misbranded as under the said law. Thus, RA 9711 provides a penalty of imprisonment ranging from 1 year but not more than 10 years, or a fine of not less than 50,000 pesos but not more than 500,000 pesos, or both, at the court's discretion. Now, if the offender is a manufacturer, importer, or distributor of a health product, the penalty of at least 5 years imprisonment but not more than 10 years, and a fine of at least 500,000 pesos but not more than 5 million pesos shall be imposed. There are other ancillary penalties, including a fine of 1% of the economic value or cost of the violative product or violation, or 1,000 pesos, whichever is higher, which will be imposed for each day of the continuing violation. So now we have covered all the prohibited claims in food labels as prohibited by the Food and Drug Administration of the Philippines. If this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website ndvlaw.com to learn more about legal matters in the Philippines. Thank you for watching Lawyer Up by NDV Law. Once again, I am Atty. Karlo Nicolas of Nicolas and the Vega Law Offices.